If you're in the family law system, divorcing a high conflict personality or a narcissistic personality, what you will soon discover is that they do not believe that often that they fall within the realms of the law. The law doesn't necessarily apply to them. So even if you've worked hard to get a support order, whether it be child support, spousal support, it falls within this similar category, and they have not complied with that order, they are actually in default. So it's important to understand what happens when somebody goes into default in the system regarding this. Hopefully you built enforcement into the original court order. And if you have, there's a lot of powers the governing agencies have to ask your ex-spouse to be in compliance, or there is punitive or damages that they can levy against your spouse. They also have powers to be able to garnish wages or tax refunds, and there's another or several different ways they can actually garnish money direct from the source and reroute it to deal with the default in the support. However, if you have not built enforcement in and you're not yet working with the governing agencies that deal with enforcement, you will have to go back and do another motion, and you will have to either build in the enforcement if you haven't built it in, or ask for a motion to have a judge order compliance of the first order that you made in the beginning. And if you find yourself in this situation, it really can take you down. It's very disheartening. It's emotionally, mentally, financially draining, and you will really see that the family law system is not necessarily based on fairness or justice, because this part is not fair at all. What comes also into a system, if you have to go back and deal with a motion to enforce compliance of a previous order, is a built-in tool in the family law system that may ask you to offer a settlement. And what that means is, if your ex is in default of, let's say, $40,000 of support, you may be asked to throw out an offer to settle for perhaps $25,000 or $30,000, or you can be, in circumstances, you can be asked to pay your ex's court costs to go back and deal with this motion. And the alternative is that if you throw out an offer to settle that results in your ex refusing to take a very reasonable offer to settle, they in fact may be asked to pay your court cost. Either way, what happens in this situation is the support payer, and in this case your ex-spouse, gets off the hook just a little bit. If your offer to settle is $10,000 less, by going through this system, they have had to pay $10,000 less support to you. And in this way, the system almost rewards non-compliance outside of having all the tools the governing agency has to enforce it. And I share this with information with you so you can prepare. And I feel it is my mission to educate you, to inform you, and to empower you, because knowing some of these tools exist, or some of these negative circumstances exist, can help you to better prepare, better plan, and understand strategies as you go along. And that is why I share this information with you, and I hope you will use that information for the betterment of your planning process and strategies moving in your family law case. So